and welcome to the our afternoon panel on lawful access and privacy considerations. We have a very distinguished panel of experts in and out of government, lots of experience dealing with these issues. I think, you know, we heard in this morning's panel about the efforts or the discussions that are going on within the OECD about lawful access, and so that's important. I mean, from from a multilateral perspective, that really does provide a lot of grist, I think, for our panel. You know, many of us over the years have spent most of our careers working on adequacy and sort of what I guess I would consider more the bilateral considerations of lawful access to data and privacy considerations. But particularly, you know, the issues that are before us today, they're not new issues. They're hard. They're vexing when you come to national security and law enforcement. And so there are no easy answers, which I think is why in some cases it takes a while to kind of get to some of the solutions that we all want to see. I think we can also have, you know, a robust discussion about, we're looking for examples of you know, where we can go going forward, and so some discussion of the cloud and the Cloud Act, I think, might be in order. But, you know, the past really is prologue, so we want to help to use this panel to sort of, from the expertise, to talk about some of the experiences that we've all had in the past and how that might be able to shape the future going forward. So we're very fortunate to, like I said, have such a distinguished panel. And I'm just going to go down the row and introduce everyone, and then ask each of the panelists to, you know, spend a couple minutes on opening remarks. But we have Peter Wynn. Peter's the Acting Chief Privacy and Civil Liberties Office at the Department of Justice. We have Will Mary Escoto, who's a U.S. Policy Analyst at Access Now. John Miller, who's the Senior Vice President of Policy and General Counsel at ITI. And then last and certainly not least, Bob Litt, who's of counsel and at Morrison & Foerster. So, Peter, let me turn it to you and ask you for opening remarks.
Thank you, Dan. It is an honor to be here, particularly with a panel like this. I want to try to set a little more of a big picture, maybe a sketch of the forest instead of the trees. When you talk about all these different issues, sometimes you feel like you're playing whack-a-mole. I think for me, it's helpful to think of the difference between a regulatory model when information was on paper to a world where information is really in electronic systems. And you know, when information's on paper, you have a property right in your paper, you have control over your paper, you can put it in your pocket, you can lock it up, the individual can protect it. When information is in systems, it's really more like water in a river. And you don't want to be damming up the river before you ask the question how the salmon are going to get upstream, or how the farmers are going to get the water they need to irrigate their crops and so forth. You're dealing in a multi-stakeholder environment, and the word control doesn't seem to work anymore, and people start using the word trust, because that's really what we're trying to build, our communities of trust. Because without that trust, not only with the data users, the people have interest in the data, particularly the individuals, obviously, but other stakeholders. And the OECD process, as you know, is dealing with a particular group of stakeholders, the law enforcement and national security community, but and those aren't even the only stakeholders for governments. The healthcare community, the healthcare regulatory bodies, the financial regulatory bodies, or just name a few. Enormous amounts of data is being reviewed, accessed, analyzed to make sure that the markets are not infected by insider trading and corruption, that our drugs can be safe and effective, based on real research and not snake oil. So the need for trust has really become international, because data is inextricably intertwined within the international frameworks. International commerce is completely dependent on inextricably intertwined data. And so even though I'm going to be spending a little time talking about the OECD trusted government access, it's more OECD law enforcement national security trust as opposed to other forms of government access or other stakeholders that may have important, in other contexts. It's not just the consumer and the platform and law enforcement national security agencies, but what about the content providers? What about the advertisers? There's a wide body of stakeholders, and every governance system has to basically make sure that all the stakeholders are heard. So OECD is really a remarkably good forum to do that. It's a good place to, and they have a long tradition of reaching out to stakeholders, not simply the different governments that themselves, because they all are democracies. The thing about democracies is they're very good at multi-stakeholder engagement because they've got legislatures.
Right.
And that's what legislatures do. But they also, at the OECD, reach out to civil society organizations pretty effectively, as well as the business community, and are generally open. And the goal is to make sure that everybody that has equity in the issue participates and is heard, and their views and their concerns are addressed. So I think it's important to first distinguish that process from what's going on in the Privacy Shield. I'm not going to say very much about the Shield because I can't, but the Shield's a bilateral arrangement between the United States and the European Union. It relates to an adequacy decision. And that adequacy decision has to meet the European Union, i.e. the European Court of Justice's rules, and will have to do so if it's going to pass muster or not. What the OECD process is, and it's easy to mix them up, is I would say an empirical process where we're bringing experts in, not simply from the privacy community, the commercial, financial ministries and so forth, but the law enforcement national security communities in the room too. And they really know what their laws provide. And the member states, including the member states in Europe, are coming in and they're putting their cards on the table in terms of what their laws look like. And what we've discovered, as Audrey Plonk said a little bit earlier today, is just how remarkably similar the frameworks are in Europe, Japan, other countries in the United States. And I wanted to just say a little bit about why I think that's the case. When you're a legislature, and a lot of this stuff is legislation that you're looking at for commonalities, you own the responsibility not only for privacy, but you own the responsibility for national security and law enforcement. And Senator Markey, he may be a privacy advocate, but he also owns a responsibility for law enforcement and national security. And in a legislature, you got to balance. And that balance is usually faced with the constraints of not wanting to make the public less safe in terms of law enforcement, and not wanting to make the nation less safe in terms of its national security, and wanting to make sure people's privacy is protected. And in a democracy, we all know authoritarian countries don't protect privacy. We forget the reason democracies stay that way is because they have strong privacy protections. Privacy is an insurance policy to keep your democracy, which gives legislatures an incentive. If they needed one in the first place, it gives them a strong incentive to protect people's privacy. And the U.S. Congress learned that lesson after Watergate in a very significant way. In France, they had a similar challenge. They've got the CNIL that was also in nearly all democracies. There's this recognition that we have to protect privacy if we want to stay a democracy. The third thing that probably explains it's not as if the legislatures in all these countries got together and compared notes before they came up with their laws. And they're all incredibly similar. But it also, I think, helped that the European Court of Human Rights, which you don't often realize is older than the European Union. It goes back to 1953. And it has a lot of case law. You know, the Supreme Court has our Supreme Court has a lot of case law, and other countries, equivalents. Japan has an equivalent, and they kind of read each other's decisions. So that's probably it's probably overstating it to say you don't compare notes, but the courts are reading each other's work. But the fundamental goal is the same in all the democratic societies, which is we own these responsibilities, we have to engage in a balance, and we have to get the balance right in a way that protects people's privacy and also ensures public safety and national security. So that balance, when you strike it and you own those responsibilities, may look different from a balance that's struck by a court, for instance, the European Court of Justice, that is actually not European institutions, that is, don't have competence over law enforcement and national security. They strike the balance differently there. So what I want to acknowledge, however, on part of my European colleagues at the Commission, particularly people like Ralph, who you heard today, and others who he works with, is how they become educated in the importance of this multi-stakeholder world that we live in, and how critical they recognize hearing from all the different stakeholders is. And when you come up with frameworks, you don't want to be, let's put it, as a joke, when I practiced law in Texas for a while, and I asked there's an expression in Texas when you are over a lot of people, and it's called walking in the graveyard, where you're over a lot of people, but they're not all listening to you. And that's a problem that sometimes we run into when people start engaging in, aspirational lawmaking, where you're not focused on getting buy-in from all the stakeholders. And at that point, you can be walking in the graveyard, where you've got a law that is on the books, but it's not a law on the ground. One of the things about a really robust democracy that you see all over the world is that when you get at least 50% of the people to support a law, and usually a lot more, it tends to be enforced much more effectively. That's law on the ground. And what I like about the OECD process is it's law on the ground. It's really what works. It's really what's passed the test of time. It's more, United States, we talk about the common law, which is evolving. American Law Institute, for instance, will put together restatements. So I'd like you to think of the OECD process as being similar to an American Law Institute restatement, where this isn't about the lowest common denominator. This is about what principles are shared in democracies and pass the test of time. And hopefully you'll see when they finally become public that the countries that will not be able to meet those principles will be the ones that actually are authoritarians, because they are defined by the fact that they can't meet those principles. So I want to pass on and my colleagues.
Thanks, Peter. You've given us a lot to chew on, so thank you for that opening. Will Marie?
Hey, everyone. It's great to see you all. I'm happy to see so many different people from different backgrounds. And I will give a special shout out to all the law students I've seen in the building, too. So that's wonderful. Please keep coming to different conferences and building your knowledge. First, I want to thank Forum Global for inviting me to this panel and the opportunity to really highlight the importance of civil and human rights when it comes to government access to data. I'm here on behalf of Access Now. We are an international organization working to defend and extend the rights of people across the world. Let me get this closer. So data protection is a fundamental right, and Access Now promotes data protection policies and laws through different campaigns, like the Ban Biometric Surveillance campaign, and partnerships with groups like All Out, an LGBTQ+ organization. We worked with them to expose the threat of automated gender recognition and the use of AI systems to predict sexual orientation. One of the major things that I want you to leave away with today is that privacy rights shouldn't come with a price tag. And in states where abortion is banned, police and prosecutors have wide latitude to access our most sensitive data and build a criminal case against people who are seeking abortion or medical providers. But you already know this, because it's already been in the news. And we're already seeing the police use digital evidence like text and web searches against women facing criminal charges for ending their pregnancies. We need federal legislation to address this. And there are proposals in Congress. I'm sure you guys have heard of the American Data Protection and Privacy Act, which has several key provisions. But there's also the My Body, My Data Act, introduced by Representative Sarah Jacobs, that would protect the privacy and safety of people seeking reproductive health online, or health care, excuse me. There's also the Fourth Amendment is Not for Sale Act that would close legal loopholes, and it would stop the harmful and unconstitutional sales of personal information to government authorities without a legal warrant. Human rights harms are inevitable when we allow companies to sell invasive and flawed technologies to law enforcement. Facial recognition and biometric recognition technologies you'll hear me speak about today, by design, they threaten people's rights, and they've already caused significant harm. Historically, misidentification has been a huge factor in sending innocent people to prison. And in the US, there are already at least 3 public cases where the police have relied on erroneous face recognition identifications to make wrongful arrest of Black men. Simply put, the police go way too far when they seek facial recognition matches of people assembling peacefully to make their voices heard. We've seen that too. And it's especially troubling when they are protesting for police reform. So, applications of facial and biometric recognition tech, when they make inferences and predictions about our emotions, about our gender, about our personal attributes, we all suffer from serious fundamental flaws. They suffer from serious fundamental flaws in their scientific underpinnings. So there's really no technical safeguard or legal safeguard that could ever fully eliminate the threat that they pose to our human rights, that they pose to women, to Black, Latino, Indigenous communities, and other marginalized groups. So they shouldn't be used in public. They shouldn't be used in publicly accessible spaces, either by governments or by the private sector. The consequences are too severe. So if we really want to talk about safeguarding public trust and consumer confidence, we need a robust process to validate the claims that these companies are making about how they're using our data and what systems they're using. The US has to enforce and develop the highest standards of human rights when it comes to artificial intelligence systems that are designed, that are deployed, and that they're developed in the United States. We need stronger federal privacy protections, with prescriptive guardrails to mitigate the risks associated with data harvesting and the sale of that data to law enforcement. So I'm looking forward to engaging with everyone here on the panel, with the audience, on the pitfalls inherent with government access to data, facial recognition, and really how to forge a way for transparency, accountability, and equity. And I'll hand it over to John.
Thanks. John?
Thank you, Dan and Wilmari. I also want to thank Forum Global for organizing and hosting this event. I'm certainly pleased to have the opportunity to represent ITI, or the Information Technology Industry Council. For those who don't know, ITI represents 80 of the largest and most innovative technology companies, really from across all segments of the tech sector: hardware, software, services, networking equipment, and everything else. I think importantly, we are truly international and transatlantic. 25% of our members or so are headquartered outside of the United States, and certainly all do business in the EU and globally. And a global perspective is really important for all of our policy work, and certainly I'll try to bring that perspective to the conversation today. And I know Peter provided some big picture remarks in his opening. I'll also take a step back, but really and talk about data and trust and these other issues from the tech industry perspective, for sure, right? I mean, because the title of this panel is about government access and privacy, but I think it's just really important for everyone to understand that we're not just talking about privacy and national security and law enforcement. We're also talking about data and data flows. And really all three of these things are important for different reasons, right? I mean, sure, of course, privacy is an important fundamental human right. It's critical to trust, and the concerns are very valid around what the rules for government access are. National security and public safety are also important. It's a core responsibility of all governments. And data flows, which I would include as inclusive of data innovation, digital trade, both of which depend on the ability to transfer data, are also important, and they're critical for economic growth. But they must be trusted data flows, and Peter mentioned that. So, I think collectively, government, citizens, the business community, civil society, we need solutions that address all three of these priorities, not just one or the other. And in particular from the business standpoint, and I'm sure we'll get into this in the discussion, unfortunately, business does get caught in the middle sometimes on some of these things. But how do we get there to solutions that can address all three of these, some would say, sometimes seemingly opposed, groups of concepts? I mean, globally there has been a lack of shared understanding of what the appropriate norms are or should be for achieving government surveillance needs while protecting individual rights. And this disconnect has created a significant commercial impact, including disruption to essential data flows for businesses, government, citizens globally. So we need solutions, and we need solutions to solve all three of these issues, not just one or two. I mean, sometimes there are so-called solutions that are suggested in a variety of contexts, such as data localization policies. But solving for one of these problems and then undermining these other important interests is really not a sufficient answer. I think the truth is that we don't have the luxury of sacrificing one for another, but I also think that the truth of the matter is that we don't have to. And if we focus on those commonalities as opposed to the differences, I think we can make more progress. So Peter mentioned the OECD process. I do want to talk a little bit about that as well, because I think it's really important for solving for some of these problems, and really beyond the process itself, the approach and what it represents. As Peter mentioned, the U.S., EU, member states, economies like Japan, they're all democracies, right? Share a lot of common values with each other, and we certainly need to pursue all of those key interests and while preserving trust. I mean, the OECD work on trusted government access to private sector data is so important, and I think it provides reasons for optimism because, again, just to reiterate and underscore three things. It's a global conversation, right? This issue has been very prominent in the transatlantic context, as Dan mentioned at the outset. But ultimately, we need to have a global conversation, and we need to drive toward global, multilateral, scalable solutions to this complex set of issues. We're living in a an environment where technology is global, data is global. If we have rules and laws, in some places and not in the other, ultimately it's not going to be helpful to actually make progress, particularly with respect to authoritarian governments or even criminal actors in a variety of contexts who are interfering with data flows. Second, breaking down the stakeholder silos is really important, and it's really important for durable long-term success, not only to have government and industry talking to each other and having governments talking to each other, but also having civil society as a part of those conversations. But really more importantly, there's a lot of siloed activity within governments, oftentimes where privacy professionals are perhaps not talking to the national security and law enforcement professionals. And those conversations appear to be happening at the OECD, and I think that's really important. And third, maybe we can get more into some of what we hope is being discussed at the OECD based on what has been published. It's a lot of these issues. As Dan said, these issues are coming up and have been coming up for years. But a lot of the issues that are on the table at the OECD appear to be things that are really important in a variety of other contexts. Transatlantic Data Privacy Framework, for instance, things like redress and making sure that data collection is carried out in a necessity and proportionate manner, oversight, other things. So, just to close, the OECD is not a silver bullet solution, but it's an important part of the puzzle, and along with significant work being done elsewhere, including the context of the Transatlantic Data Privacy Framework, the e-evidence directive in the EU, and the Cloud Act, which I believe Bob's going to say a little bit more about in his opening remarks. These are all pieces of this puzzle, and I think as we move forward, hopefully we'll really have more ability to focus on what we have in common rather than what is different. So thanks again for the opportunity to join this conversation, and I look forward to the discussion. Turn it over to Bob.
Thanks, John. Bob?
Yeah, thank you. I want to join in the thanks to Forum Global for having this conference and for inviting me. Because I've spent about half my career in national security or law enforcement, I tend to be invited to be on these panels to present the government's point of view, even though I'm no longer in the government. But I think I do have some insight into it. I want to speak a little more concretely about one way in which some of these problems of conflicting legal regimes and cross-border data have been dealt with. It's a very narrow slice of the problem, the Cloud Act, but it is, I think, an effective mechanism. Couple of misconceptions about the Cloud Act that maybe nobody in this room shares, but I certainly see out in the real world. One is it only relates to law enforcement. It has nothing to do with intelligence or national security collection. It's just a law enforcement mechanism. And indeed, it's limited to the investigation of what are defined as serious crimes. Number two, this is not a mechanism for sharing data between governments. It's a mechanism for one government to use its own lawful processes to collect data that's outside of its physical territory. And finally, the Cloud Act doesn't create any new basis for the U.S. or any other country to acquire information for law enforcement purposes. If the U.S. wants to get data that's located outside of the U.S., there has to be a valid basis under U.S. law for doing it. There can be a search warrant, there can be a subpoena, but it has to be done in conformity with U.S. law. The same is true for foreign countries under the Cloud Act. They have to issue process in accordance with their own law. So as I said, what the Cloud Act is an effort to work with other countries to enable these countries to have access to data that's necessary for criminal investigation and prosecution. And basically, the Cloud Act was intended to address two different types of conflicts of laws. One arises when the U.S. seeks data from a provider that another country prohibits the provider from producing. And the other is when a foreign country seeks data from the U.S. that the U.S. prohibits the provider from producing. Tongue twisters there. And these problems have become more and more acute as data goes more global and, frankly, law enforcement investigations go more global. So turning first to the issue of foreign countries seeking access from the U.S., the basic problem is a statute called the Stored Communications Act. That's a U.S. law, and it is a general prohibition on electronic communication service providers from producing information about communications or the content of communications unless the request falls in one of a number of exceptions. One of those exceptions is for law enforcement, authorized law enforcement requests, but it only applies to authorized law enforcement requests from U.S. authorities, not foreign authorities. So if a foreign law enforcement authority wants to get data from a U.S. entity, it can't do so because the entity is prohibited by the Stored Communications Act. This is true even if the UK is investigating a UK person for a UK crime, but that UK person had a Gmail account. The UK cannot get those emails from Google. Instead, they have to go through mutual legal assistance, which is a very time-consuming and burdensome process. That's one side of the conflict of laws. The other side is if the U.S. wants a company that's subject to its jurisdiction to produce data that's located outside of the United States. And it's always been the position of the United States that it has the authority to do that. And that was basically unchallenged until a case that you may be familiar with a couple of years ago involving Microsoft Ireland, when the United States Court of Appeals for the Second Circuit held that at least as to one category of law enforcement request, a warrant under the Stored Communications Act, that could not be applied extraterritorially. The Supreme Court was going to hear that case, and I think most people thought it was going to reverse it. But in the meantime, the law was uncertain. And so these are the two kinds of problems that the Cloud Act was meant to address. The first thing it did was codify into U.S. statutory law the principle that the U.S. can get data from anywhere in the world from a company over which it has jurisdiction. And it also codified the rules that courts are supposed to apply in resolving conflicts between U.S. law and foreign law. The second thing that the Cloud Act did was amend the Stored Communications Act to provide a mechanism for foreign governments to get information directly from U.S. providers. Essentially, the procedure is that the United States can enter into what's called an executive agreement with another country if the Attorney General certifies that that country has adequate protections for privacy, civil liberties, and due process. Once there's an executive agreement in place, the foreign country can serve process issued under its law on the U.S. company, and the U.S. company has to comply to the same extent that they would if they were a foreign company. This is something that foreign countries very much wanted. But again, it did not give any new basis to get authority. If the UK does not have authority under its law to get this information, it can't use the Cloud Act. To date, there have been two executive agreements entered into. One is with the UK that's coming into force in a couple of weeks, and one is with Australia that was signed in December and is awaiting legislative review. There have been negotiations with other countries. There have been negotiations with the EU, which are particularly complicated, both because the EU feels it first has to agree on its own internal rules for cross-border data flows, and second, because the U.S. is not comfortable negotiating an agreement with the EU as a whole. I think Peter mentioned earlier that the EU doesn't have competence for law enforcement. So requests would come from individual countries, and without naming names, I think there are some countries that are members of the EU that the Attorney General might have difficulty certifying meet standards of protection of civil liberties. So that's the Cloud Act in a fairly large nutshell. I think it's a useful model for carving off a narrow problem and resolving it essentially bilaterally in a way that enables both protection of privacy under an individual country's law, but also the enabling of law enforcement activities. And if I might, I want to also just turn to another thing and kick off what may be an interchange a little bit by picking up on the comment earlier that says privacy doesn't come with a price. I disagree. Privacy always comes with a price. We could have much better protection of privacy in the country if we didn't have search warrants or we didn't have electronic surveillance. But those are trade-offs that we make because overall the social benefit of that degree of intrusion of privacy structured in that way is perceived to outweigh the intrusion on privacy. And I think this is where Peter's comments pick up. We do that through the democratic process. These are social judgments that are made through the democratic process as to what kinds of intrusions on privacy do we want to tolerate for what purposes. And I think that's the framework in which we have to address all of these issues. And I'll stop there.
Well, thank you. Thank you very much. It's terrific comments. Let's just start. Let me turn to Peter. You mentioned a lot of things, but in particular, some optimism around the work of the OECD, and drew out the distinction. Some of us have been doing this for so long, we kind of forget these distinctions between bilateral and SHIELD and multilateral, and drew upon a number of, I guess, positive examples, things that are coming out of the OECD, and it's not perfect, but the potential, along the lines of what Audrey mentioned. But if you were to sort of look forward, where do you see things developing in a multilateral sense? You mentioned healthcare and financial, and then those are big areas that we're eventually going to catch up to us. But where do you see the trend, the multilateral trends going? If we can build upon the OECD, but where do you see those? Where do you see that going in the next few years?
That's a wonderful question. Thank you, Dan. I can't speak for the U.S. government on this one, but I think that it's important to see the OECD is just biting off. It's just one.
Yeah.
You eat an elephant one bite at a time, right? So the law enforcement and national security issues are simply one very important part, that problem that needs to be sorted out. It's caused a huge amount of suspicion and mistrust, and clarifying what everyone is actually doing. All democracies, just the great, how similar everyone is behaving with respect to effective oversight and accountability in law enforcement and national security. That's a really important step to build trust.
Right.
Because trust is destroyed by misunderstandings and suspicion, and being a little more open and transparent about what everyone's doing helps a lot. And want to acknowledge, while I'm on transparency, I just want to acknowledge Bob for something that he didn't take credit for, which is the work he did with Director Clapper and Alex Joel when he was in the intelligence community leading a transparency effort after the Snowden disclosures that really transformed how the U.S. intelligence community viewed its relationship to the public. And I think people in the U.S. intelligence community, after Bob and Director Clapper did their work, see how critical it is for them to to get buy-in from the public. And we're seeing this in Europe particularly in connection with the Ukrainian situation, where European intelligence community and the U.S. intelligence is starting to pick up a lot of trust because people start realizing just how important what they do is.
Right.
That's super important, but it's just one bite.
Right.
And the healthcare issues, the COVID epidemic has really made us conscious of the international data transfer questions associated with pandemic, World Health Organization work, and the work of both, not just the drug manufacturers, but the the work of drug regulators, the work of medical research institutions. This is all transnational now. That has to, we need a better solution, because you can't data localize in this environment
Right.
and maintain the same degree of reliability of our science. Financial data is another good example. We need a solution. If there are a lot of companies in Europe that are European financial companies that are transferring a terabyte of data a day to FINRA, so the SEC can make sure that people are not engaged in insider trading. That's kind of like, well, we don't want to look at that, but there's huge gaping holes there. And we need to make sure that we can build governance structures that address those types of concerns, because those companies are now becoming more, you don't want to be chilling scientific research. And you don't want to be selectively enforcing laws that ostensibly prohibit certain activity, but you're just going to let them do it because maybe the law needs to be tweaked. Law itself is a continuous improvement process.
Right.
And the way you identify, and that's what it needs to be in a democracy, is you constantly, you don't necessarily get it right the first time, So, and that's true for all these different frameworks and these multilateral engagements. And it's not just the different countries, it's the different stakeholders. Getting their views on the table, getting them talking to each other is the only way to build trust, which is going to be necessary to develop the kinds of governance structures that are going to have to be in play in a world where, as everyone recognizes, the data is inextricably intertwined.
Thanks. Wilmer, I want to come back to you and ask you to elaborate. I mean, your on your comments, sort of, Fourth Amendment, government access to data, sharing of data. I mean, particularly, is it your experience that post-Dobbs, there's a greater awareness of government access to information? I mean, one could argue that we should have been aware of it, all along. But it seems, is it the case that in the post-Dobbs world that there is a much brighter spotlight shining on government access to data?
I hate that sound when I slide it across. Absolutely. I think if you think about the context of the Dobbs ruling, right, we're rolling back on decades of a law. You said something earlier in regards to, well, people should have known, right? They should know. That's implying. That's implying informed consent. That's implying that people know that what the companies are doing with their data, how it's being used, how it's being sold. And that's not the case. We keep hearing that data being on the internet is inextricably linked to our lives. Everything is online. So when you're, and I pose this to the audience, if you're trying to tell someone not to use an app or online or internet searches, you're removing them from society in essence. So there isn't informed consent. There isn't clear transparency. There's not oversight. There aren't guardrails. So why are we putting the guilt on consumers, on people? you know, a lot of these laws that were created way before the internet evolved. You know, there's been technological advancements in the last couple of decades, and a lot of our laws haven't, you know, protected against that. And earlier, you know, Bob mentioned these trade-offs, you know, and that really goes to that illusion of consent and transparency, and that hasn't been the case. So yes, you know, the government has been accessing our data in different ways. I think that subject matter experts, certain people, of course, knew about it, but it's similar to, you know, the net neutrality debate or other tech policy things that are starting to become more of a household dialogue conversation. Yeah, so I will say that, yes, it is absolutely, you know, the Dobbs ruling was a catalyst to this, and we've seen the implications. We've seen, I believe it was in Indiana, you know, we've already seen these cases where the police are using this data. So it isn't new, right? The government's been able to access emails and different things as well. So I'll stop right there.
Yeah,
That's all I
thank
have
you.
to say there. Thank you.
John, over to you. And thank you for your comments, but I wanted to sort of ask you to expound upon something that you said, that you know, privacy is a fundamental human right, but that business gets caught in the middle. I mean, in national security and law enforcement, and that was certainly the case in sort of early Snowden. You know, business was was really left to fend for itself for some period of time, which was unfortunate. But you know, looking back on the last decade or so, how would you characterize the changes? You know, I mean, in the relationship, you know, between business and law enforcement. I mean, particularly post Snowden, because it seems as though there's been, I mean, and to Peter's point, or the, you know, other discussions about democracies, we don't always get it right, and sometimes it's a little messy, and it's very messy. But I mean, we're you know, we're continuing to work on it. But what do you see as the sort of most significant developments really in the, you know, decade or so post Snowden?
Well, thanks for that question, Dan. You know, I mean, I think, you know, it's hard to generalize on that answer, because I do think that it has been an evolution, you know, over the past, whatever it's been, 9 years or so since the.
But who's counting?
Yeah, who's counting?
Who's counting?
Exactly. You know, and look, it was probably a pretty tense relationship all around, just in the immediate aftermath. But I mean, I do think, you know, if we look at the time period, you know, since whatever it was, 2013 to now, you know, I think Peter mentioned something that has clearly been a positive evolution and a change in U.S. Surveillance law and practice, and I think that is with respect to transparency. You know, Peter credited Bob, and I certainly won't dispute that. But you know, I mean, I think on a number of fronts we can look at that. I mean, at least from my perspective, I mean, it does seem like there's much more willingness to be more transparent on the government side, and we've seen a whole host of different things, you know, since then, you know, PPD 28 and a whole bunch of practices that were rolled into a memo that was put out in the aftermath of the Schrems II decision by the Department of Justice, ODNI, and the Commerce Department, for instance. But I think also, like, if we look at some of the significant changes that multiple stakeholders work together to achieve since Snowden, I mean, I think one of them again, I think a really important milestone was the passage of the USA Freedom Act.
Yep.
I think, there's a lot of good in the USA Freedom Act, but I think one of the most significant things was, the fact that tech companies, the business community, actually, I think, working with civil society in many ways, we're on the same page and trying to get that bill over the finish line and trying to bring more transparency and allow for transparency reports to be issued. Again, I'm sure that there are many who would always say we could go further, but if we look at it through the lens of comparative lens, I think on the transparency front, both from the company standpoint and from the government standpoint, that's been one of the most significant changes. Since then. And just to say one other thing about, businesses being, quote unquote, caught in the middle. I don't know if I should use that phrase or not, but I do think that, look, I mean, companies, at least the companies I work with, do absolutely support and value, privacy as a fundamental human right. Companies also, the reality is they have to respond to legal process and subpoenas when it is issued to them, and they certainly contest those subpoenas and other law enforcement access requests when appropriate. But they can't protest on the grounds that they think privacy is a fundamental human right. They need to protest it on valid legal grounds. And as Bob and Peter have said, I mean, we live in a democracy, and we have various different laws that try to get that balance right. And USA Freedom is an example of where the balance was recalibrated, and I'm sure we'll have future recalibrations in the future. Thanks.
Thanks, John. Bob, I want to come to you. And thank you for setting the record straight on the Cloud Act. Very important. One of the things I was struck by on the earlier panel was, especially with and this is more in the context of the OECD, but a lot of discussion about interoperability and convergence, and that's all positive. We haven't had much of a discussion today, thankfully, although I want to ask you this question. The question of data localization and, the rubric that we hear a lot from Europe on data sovereignty. How do you, and that just seems to be becoming more and more popular in Brussels in particular. But how do you address that? How do we're on one hand we seem to be making progress in terms of interoperability and convergence, but then on the other hand, there seems to be a lot of discussion in some quarters that sort of relate just back solely to data localization and data sovereignty. I mean, how do we square the circle?
If I had the answer to that, I could make a lot of money. Seriously, though, I think you have to distinguish between data localization as a cartel protection, for want of a better word, to bring business back to the country, data localization as a simple fact of technological life, and data localization as a way to impose your own country's rules on the data. With respect to the business aspects of it, there has always been a sneaking suspicion in the U.S. government that a lot of the drive for data localization is a desire to recapture business from U.S. companies. Mm-hmm. There's not much that can be done about that except name it and shame it. I think with respect to the application of local rules, this is where I think the kind of agreements that Peter has been talking about and the Cloud Act and hopefully the new Privacy Shield will manage to harmonize the idea, separate the idea of where data is stored from who can get access to it. Particularly in an environment where you don't always know where the data is stored. The most important mechanisms are going to be mechanisms that are set up to ensure that wherever the data is, if you need it for a valid legal purpose, you can get it. And that people can't evade investigation by saying, I want to ensure that my data is all stored in some country that won't produce it.
It's very helpful. I mean, it's a good context, or very, very thought-provoking. Want to include the audience. We're a little short on time, but do we have any questions from the audience? I see one here, and then
Good afternoon.
Ken, please.
My name is Amar Islam, and this is the second time opportunity given to me to have a question. So thank you so much for the whole day arrangement to Forum Global and to host this data privacy. So a question, very short. I don't want to take any time. Everything has been discussed regarding the data privacy and all the subjects with the best granularity from the experts. But I think one thing that we need to add before the data, I have a question to Mr. Robert Sleet, that since he has uttered about the Cloud Act, so recently we have seen that very good number of satellites are being sent from Fed and also the private sector. So that carries a lot of data, which is space data. Now, today I think there is a news that NASA declared that they have been their data breach in the beginning of this year. So is there any steps or plans to protect those space data? Thank you.
You're a little bit out of my area of expertise here. I do think you probably need to distinguish between data that flows through the satellite, private communications that are transmitted by satellite up and down, and data that the satellite generates or that the ground stations generate. I don't know what this particular data breach you were talking about was, which kind of data it was, but the satellites are used by private companies, and the breaches that I think are much more likely to happen are at the level of the private companies using the data. I don't know if others have more knowledge about this than I do.
I mean, I can, maybe not much, but I can just say that, one of the other issues that I do a lot of work on is cybersecurity, critical infrastructure protection, and in that context, certainly, the Cybersecurity and Infrastructure Security Agency, which is part of the Department of Homeland Security, I've been involved in several conversations, and I know there are ongoing conversations about, the kind of the space sector, so to speak, and I think an evolving view of thinking of that more as kind of critical infrastructure that needs to be protected as part of the various different ongoing efforts that are going on on that topic, I would say.
Well, and I also know, this has been more in Europe, but the Forum Europe has been actively engaged in Brussels on questions around space. So maybe talk to James and Annalise and find out more what Forum Europe is working on. But we have Ken, one more. You get the final word.
Thank you. Ken Propp from the Atlanta Council and Georgetown Law School. My question goes to the impediments to a U.S.-EU Cloud Act e-evidence agreement. Bob mentioned that there's concern in the United States about requests that might come from illiberal members of the European Union. That obviously is also a concern for European law enforcement. If that issue is managed to be solved within the EU in their own legislation, could that provide a model for how it could be addressed in a US-EU agreement? And the second question, related one, is the European Union is unhappy with the fact that a Cloud Act agreement would not be, in the US view, an exclusive means to obtain e-evidence. How do you see that issue moving forward? Thank you.
On the first point, I mean, I think the answer is it depends upon how the European Union resolves their issues. There certainly could be ways that their own internal e-evidence solution could help deal with the problem that the U.S. feels it faces with respect to the varying degrees of due process in countries. But until we see what they're actually coming up with, it's not going to be possible to say in the abstract, oh yeah, this is going to solve the problem. Your second question was? Oh, exclusivity. Yeah, I mean, it's always it's not exclusive either way. The agreement with the UK specifically says this is without prejudice to any other lawfully available means, either for the US or for the UK.
I think that's it. Well, thank you all for your attention. This has been a very substantive panel, a lot to think about, and we will stay tuned for future developments. So please join me in thanking the panel.